Welcome, everyone, to tonight's panel on ethical considerations in the practice of New York State Article 81 guardianship law. I'm Kimberly George, president of Project Guardianship, co-sponsor of this webinar series. This event is the fourth in a series that began in March 2021. Our first panel was on Article 81 guardianships during COVID, at which we heard from a panel of guardianship judges from the 5 boroughs of New York City on the impact of the pandemic in their parts. The second in the series was in June 2021, and we focused on a statewide perspective, and we heard from people working in Western, Northern, and Central New York on practices and needs in their jurisdictions. The third panel in September was on ethical considerations with a focus on the guardianship petition and the hearing. And tonight, we're hearing from a panel of experts on ethical considerations, moving on to issues that arise post-appointment and around the termination of guardianships. If you missed any of the first 3 events, you can watch the recordings on Project Guardianship's website. Project Guardianship was founded in 2005 as a program of the Vera Institute of Justice to fill a gap in the guardianship system that left unprotected a population of largely low-income aging adults and people living with disabilities and mental illness who lack family and other supports. Since its founding, Project Guardianship has demonstrated that a nonprofit program centered on human dignity can enable people with little resources and support to live more safely and independently while also saving public dollars. Project Guardianship offers a comprehensive model of guardianship in which each client is served by a multidisciplinary team of lawyers, case managers, and finance managers. We specialize in keeping people in their homes and out of institutions, as well as moving people back home. We also have expertise in making end-of-life decisions in accordance with the law and in accordance with clients' wishes. We serve as guardian to clients regardless of their ability to pay, and we have the capacity to provide services to the most complex cases. We also provide research and recommendations for a better guardianship system and advocate for more equitable responses to providing services for people who need protective arrangements. This includes working with partners to find solutions that not only improve guardianships, but also divert people from guardianship whenever possible. We've been partnering with LegalHealth, a division of the New York Legal Assistance Group, for the past year to host these webinars in an effort to gather and share important information and identify service gaps and develop practical solutions for an improved guardianship system. To tell you more about LegalHealth, I would like to introduce Sheila Zablo, Senior Staff Attorney at LegalHealth.
Thank you, Kimberly. The New York Legal Assistance Group provides free civil legal services to New Yorkers who cannot afford a private attorney. In LegalHealth, we provide a full range of legal services, including advanced directives, Social Security disability, housing, and immigration. We partner with hospitals and community-based health organizations to provide free on-site legal services to patients needing assistance. We currently have 34 hospital and community health partners. I'll now turn to my colleague, Stu Sherman, who will lead our discussion tonight.
Thank you so much, Sheila. I'm Stu Sherman. I'm a senior staff attorney at LegalHealth, also the founder of our Guardianship and Guardianship Alternative Program, which assists caregivers throughout the New York City area accessing legal services. We have an excellent panel tonight. I'll just introduce the panelists. We'll have some moderated questions until about 6 o'clock, and then we will turn it back over to Sheila, who will ask questions that have come from the audience. So the first panelist, Jillian Ballantine-Allman, is licensed in New York, New Jersey, and the United States District Court. She is on the Part 36 fiduciary list and serves as court evaluator, attorney for the AIP, and court examiner. As a solo practitioner, Ms. Ballantine-Allman represents clients in the area of Medicaid planning, guardianship, trust and estates law, and real estate law. Next, John Holt is the Director of Legal Services at Project Guardianship. In addition to his work at Project Guardianship, John was also appointed as a member of the New York State Office of Court Administration's Guardianship Advisory Committee and is a regular presenter in trainings provided by the Guardianship Assistance Network to newly appointed lay guardians in New York State. Olga Perez has been the director of the Office of Court Administration Guardian Assistance Network program since May 2015. Prior to joining GAN, she served as the interim project director to the Vera Institute of Justice Guardianship Project. She has over 20 years of experience in elder law and previously was the director of the Brooklyn Law School Elder Law Clinic. Georgianne Karporal-Papadakis is currently the supervising attorney of the Kingsborough Office of Mental Hygiene Legal Services, where she's worked for over 21 years. Her practice consists primarily of representing individuals with mental health issues retained on inpatient psychiatric units within hospitals in Kings County and serving as counsel to clients who are the subject of Article 81 applications for guardianship. She represents clients in the civil, criminal, and surrogate courts. Finally, Rachel Gerson, who will be joining us later. She was assisting with an emergency lockout for a client today, so she is excused for being a few minutes late. She is the assistant clinical professor at Seton Hall Law School in the Health Justice Clinic. Prior to joining Seton Hall, she was the supervising attorney at the Urban Justice Center Mental Health Project, where she served as court-appointed evaluator and counsel for people under guardianship seeking to modify or terminate their guardianship. So with that, I'd like to start the questions with ethical questions around the area of the commencement of guardianship. The first question is for the entire panel, and it's very broad, which is, how does a guardian learn an IP's values and wishes, and why is it so important that they do so?
So I'll jump in and take a swing at it. You know, there are different phases of this, certainly, and for us, speaking from the perspective of an agency guardian who's coming in to these procedures, generally either at the point of appointment as a temporary guardian or post-adjudication, some of it comes to us from what we see in the papers, whether that's the court evaluator's report or from the petition. Certainly, if it's coming from a petition, you know, we were trying to be mindful of the fact that that is perhaps one side of a very complicated story, and you know, can't take everything that's in there on faith. The evaluator's reports, when done well, I think are much more neutral and can give a much more nuanced and broader view of what's going on. But you know, I think at the end of the day, the most important thing is by having a conversation and forming a relationship with the person who's under the guardianship and hearing it directly from them. It's not always possible, but that's certainly ideal. And you know, in terms of what that means for the guardianship, I think we'll hear a lot about this tonight. To the extent that somebody's wishes and preferences must be, under the statute, the guiding light in making decisions for the person under guardianship, you need to understand what those wishes and preferences are or would have been. And there's a variety of ways that you can try and glean that, but it's incredibly important if you're going to do your duty as a guardian in a way that really forefronts those wishes and preferences.
I certainly agree with everything John has said. What I would add to that perhaps is, you know, going to the IP's home. I think you can learn a whole lot about a person, what their values are, their wishes are, by visiting their home. You're seeing pictures on the wall, you know, memorabilia in their apartment, things of that nature. So I think that's a really good picture in terms of what's important to them. You'll learn about family members, things of that nature.
Georgianne, it looks like you're trying to speak with your still mute.
Sorry,
Oh, no.
I will unmute myself now. I would actually like to piggyback on both of those. And the one thing that I really would like to emphasize to everybody is that one of the early lessons that I learned when I first started this job and started dealing with Article 81s back in 21 years ago, and with my ongoing, you know, clients that are suffering from mental illness, it doesn't matter how incapacitated a person is, they will be able to some way let you know what their wishes are. Whether it's, you know, it's a person who suffers from severe dementia and has one moment of clarity to let you know, yeah, my wishes are that my money goes to the church. Or, you know, if they can't verbalize, you know, if you say something and their eyes brighten up, or, you know, they smile, then you know that, you know, you're in the right direction. Or if you know, we have 17A guardianship clients that sometimes can't verbalize that they like something, but, you know, they'll go visit a place and be like, they're smiling, they're having fun. You know that that's where they want to be. So, you know, just because someone has been deemed incapacitated doesn't mean that they can't let you know what they truly, truly wish and what their values are. And I agree, not only speaking to them, but going and, you know, going to their apartments. You got to become a detective, you know, at some point. You really to try to put the pieces together to figure out what their values are, what their life was like. You know, everybody had a life before they became incapacitated. And that's crucial to also helping to get the individual to comply with the guardian if, you know, they're resistant to having a guardian.
Oh God, actually just like, oh yeah.
Yeah.
I was going to follow up with you on this, which is, there's an assumption that a lay guardian might have a better understanding because they're a family member or a relative. But how do you help them tease apart, what might be their assumptions versus what might be the actual wishes of the IP?
Yes, and you're right. Many times they do know what the wishes are and the preferences. That's not always the case because you can be a lay guardian also as a friend, and they may or not know that. But one of the things that basically what has been mentioned until now, I certainly second that. One main thing that I mentioned to them is put yourself in their shoes. You have to put yourselves in their shoes, not thinking for yourself, but thinking through what that person would want. The entanglements that may come up after that because of the family relationships, that's what we're going to be talking about later. Mm-hmm. But that's basically my main advice to them.
Great. And so piggybacking on that, what role do you think cultural competency plays in the process of both assessing values and wishes and being able to act as a guardian? Georgianne or Jillian, would you like to answer that?
Well, certainly cultural competency is loosely defined as the ability to understand, appreciate, and interact with someone from a different culture or belief system, right? So, one example that why it's important in the guardianship context, Georgianne already mentioned it, if you learn that this person is, have strong religious beliefs and they tithe and do offering, and it's their custom, as the guardian, it is your obligation to really follow suit with that. It's not, your duty to come on as a guardian to say, I don't believe in this, and, I have very different belief system. It's really just, as Olga stated, you're stepping into their shoes and continuing their life as much as possible before, the guardianship even started, and also it has been echoed that with respect to cultural competency, if you learn some nugget about someone, they're more inclined to open up to you. I had a recent issue in which, it was someone from a different culture, and the social worker apprised me ahead of time as the court evaluator, if you talk to this woman about Indian food, she might be more amenable to having a conversation with you, and it absolutely worked. So it's just about showing respect and deference to someone else's culture.
And, I would also like to expand that a little bit. And I don't want to sound like an extremist, but it can mean the difference between life or death. I had a guardian come to me once, and we were talking about how one of her wards, she unfortunately had to remove her from the community and place her into a nursing home. The minute she went into the nursing home, she stopped eating. And it got to the point where the nursing home was concerned and said, if she doesn't start eating, we're going to have to, she had lost a lot of weight. We're going to have to, move to put in a feeding tube. Well, this ward was actually someone who had immigrated from Jamaica, had lived in a Jamaican community the whole time she was here in Brooklyn, and only liked Jamaican food. So the guardian was savvy enough to ask the nursing home, what have you been feeding her? And of course, it's the plain, bland, normal food that any nursing home feeds you. And the woman, her ward just did not like the food. She said, did you provide her with any food, Jamaican food? They're like, no. And so the minute the guardian was able to actually start having Jamaican food delivered, she started eating again. And she was happy and she was healthy until, unfortunately her medical, conditions unfortunately caused her to pass. But, it's something as simple as that made all the difference of the quality of life that IP had had. And she, if the guardian didn't know that, the poor woman would have been tortured with a feeding tube. And then we all know what ends up happening after a feeding tube is right, usually injected. So.
I think it's amazing how something as relatively simple as that can make such a huge difference. And I always think of it as something, especially for us as an agency guardian, where we have hundreds of clients and there are people who are always coming through the organization, that it's, cultural competency for us isn't something we achieve. It's something that we're constantly having to work at and relearn as we get new individuals into the program and having to meet them on their terms, not, as a profile or an archetypal client coming in, but as a human being who has specific beliefs and wishes and preferences. And part of the job that I've always enjoyed the most is getting to learn that. And yeah, whether that's through rifling through every paper in their apartment or having a conversation with them or however we do it, it's part of the job that I think is incredibly important. And it really does have an impact on the work in the long run.
Right.
Yeah. John, I'm actually going to follow up with you as a working in an institutional guardian capacity. What is your thoughts on the possibility for institutional guardians with changing staff and limited contacts to know IP's wishes and transfer that knowledge to others within the organization?
Yeah, I think it's possible, and I think it's something that we strive very hard to do, and it's something that we're always working to refine. I mean, it's really about how do you capture information that comes into the organization in a way that somebody down the road can understand it and interpret it and put weight to it and then act on it. And that's a real challenge because there's a lot of ways that you can record information. We have a client database that's a cloud-based system that we record case notes and things on. And we've very much always tried to take an approach that really tries to capture the flavor of the interactions with people. It's not just outcome driven, but it records statements and things they said and observations of the case managers and the little things that down the road, you may have no idea what the significance is at the time that you record it. And then here we are 10 years later making a healthcare decision for somebody, and this little snippet of conversation about, what they thought about, what happens to you in the afterlife or whatever it might be can just give you a little bit of a glimpse into something and provide a point of data that can be useful. And it's something I think that is really important. It's also something I'm concerned about kind of from a policy perspective when you have a transfer between guardians. And that kind of information I think tends to get lost in the shuffle because it's not, carrying over the balance of their guardianship account or transferring control of their Social Security. It's these very unique pieces of information that are there. So I think it's doable, absolutely. But I think it's something that needs to be intentional and really worked at and continue to be built over time.
I'd like to open that question up to the rest of the panel as well.
I work for an agency where, we have this issue at times, not specifically in regards to, guardianship, but just being able to handle clients through different offices. And I can just say, really just document, like John was saying, if at any point in time, someone may have to pick up that file in our office and represent that individual, at least they'll have something that they can look at and refer to have information about that client. If institutional guardians or any guardian just want to have a community guardian have like a face sheet that has patient's wishes, patient's desires, as information gets received, as they learn more information about the individual, if they could document it on that one sheet, like as a face sheet, that might be a good way to have important information that every single person from that agency needs to know about that individual right up front, even if it's electronic or whether it's, a paper file.
It's a good point, Georgianne, because you never know how the information is going to have to be used. And sometimes it's at 2 a.m. in the morning with a critical healthcare decision making. And if you can't put your hands on it, great, you recorded it. If it's sitting on a piece of paper in a file in your office, it's not going to do you a lick of good. So yeah, having it accessible and digestible is definitely an important part of it too.
Exactly, especially in emergency situations. And, if you're at 2 o'clock, you're needing to make those really drastic, decisions.
Great. So I want to flip it to Olga for a moment to discuss lay guardians. And, one question I have is the ability to convey to lay guardians the ethical duties they have as a guardian. When it's a professional guardian or attorney, there's an entire body of ethics and ethics rules that they abide by, that they've been trained in, whereas lay guardians are sort of stepping into this role for the first time. So how is that taught to them, and how do they learn to separate, their desires for their loved one from what their loved one may want? What are their wishes?
Yes, it's funny because I'm thinking about that question, and I know I do it. I'm trying to think, how do I organize it to bring it for them? First of all, we harp on it, and we emphasize it a lot on our initial training, which is the mandatory training. We dedicate a whole section to it. And what we do is we break down the concepts in a way that they are understandable to lay people. Because otherwise these concepts that are so easy to understand to professionals, to those folks there, it's not. So one thing is, make sure you read the order in judgment 100 times. That's your number one duty. And that's what's going to give you the basis. You are not caregivers anymore. You are now guardians, which means there's a formality and there's a review and there's a supervision. You must deal with issues that way. Think of guardianship this way. It's a loss of freedom, which may be so obvious to us, but to a regular person, it's not. You have somebody making decisions for someone else. And the question I ask them is, would you like that? Well, certainly not. And in a country that values so much freedom, as we have seen, particularly in this last year, it becomes a very, very important issue. And they can remember it that way. I also emphasize the fiduciary duty and explain to them what that is. It's such a huge trust that's being placed on you. You have to constantly say, is this for the benefit of the person? Is it for the benefit of someone else, let alone for your own benefit? So that basically also, what else do I do? I emphasize in the least restrictive alternative, which is so important, and that is new to them. The reaction of lay guardians when they learn of that is quite amazing, because they approach me and say, I didn't know that. And the way that I explain it is, look, precisely because you're taking away their freedoms, you want to ensure their security, their well-being, and their safety, but you want to disrupt their lives as much as possible, as least as possible. And so therefore, you don't want to change what they have done. You must follow their wishes, see what they would have done in that situation. Again, stand on their shoes. And then the other thing, this comes a lot. In reality, there's only so much you can do in a training. These are questions that come to us on a day-to-day basis. So what we use is the teachable moment, the opportunity to tell the person, well, this concept, this vision of the least restrictive alternative will give you the answer. For example, I had somebody recently call, the person doesn't want to get vaccinated. Should I do it? It was a great way to explain to him the importance of that, and how if he wanted to do it against the person's wishes, it had to be a court order. But he had that to keep in mind. Sometimes defending an eviction proceeding involves that, because it may mean that a person is going to be able to come out from a nursing home and back home. That's another example. The other one that comes a lot is people who call us and say, well, I would like to allow the person to have some money, to handle some money, which really helps them, A, to stay functional, retain their dignity. All of that involves these ethical concepts of the least restrictive alternative. And that can go from allowing them $20 a week to go to a diner, to somebody who called recently and say, can I give money to my brother to go play in Las Vegas because that's what he likes to do. And how that breaks down is different, but the concept is there that they're trying to make sure that they keep those values and see it as their obligation. I will say that how this plays out, tell me if I'm taking too much time, Stuart. How this plays out depends also, it's so different when it's lay guardians. It depends also on their background. An educated person or a person with a certain work background may understand ethical duties better. A person that does not know them, however, it makes a big difference if there is affection or resentment in that between the family members. So the relationship comes in a lot in this kind of situation.
Thank you. Does anyone want to provide examples of this conflict for lay guardians before we move on to the next question? We'll get back to that, not a problem. Does a guardian have a responsibility to educate their ward on financial and other matters? And can that help facilitate a termination of guardianship? I'm going to ask that to Jillian and John to start.
Yeah, it's an interesting one, Stu. I mean, what is the goal of the guardian? Is it to improve the ability of somebody to manage their affairs? I think arguably yes, to the extent that that's something that's feasible. And obviously the goal of any guardianship should be to try and see if there is a way where less restrictive alternatives can lead to the termination of the guardianship. We've had clients, particularly for younger adults who had developmental disabilities, who just weren't connected into services, where that was a realistic goal to see some improvement, less so with other population groups, older adults with dementia or people who are more likely to experience decline in their functional abilities. It may be more of a challenge, but I think the answer is yes. If there's a way to facilitate somebody gaining that ability to manage their affairs, then a guardian should pursue that. I don't know that it may not be abundantly apparent to someone that that's feasible, or how to connect them into those things, or how to get them that training or that the basic financial competence to be able to do it. But yeah.
I certainly agree wholeheartedly with everything that John has said. The guardian does have that responsibility to educate the IP about, their finances and really about any other aspect of their life, right? Once the guardian has learned, the guardian should then educate, and with the objective of really exercising what's the least restrictive, option. And, you don't want to override and overhaul this person's desires and wishes completely. So the more education and the more participation they can have in the process, the better it is, for their well-being and really for the, the overall objective of Article 81.
Yeah, if I just add a case example, it's fresh in my mind. We have a client who we've been guardian for a number of years, who's been through a cycle of just mental health issues and has been in and out of psychiatric institutions, and she's been doing really well and has gotten to the point where we've been trying to give her some more financial independence and to give her more control. And it's challenging because that added responsibility is now also kind of creating other complications with her mental health, and she has these new responsibilities, and it's kind of bleeding into other aspects of her life and the guardianship. And so it's something that's been really something we've been thinking about a lot as an agency recently, just because of how complicated that is. It's not just a matter of somebody being able to do it, but also what does it mean in terms of their ability to manage all of their affairs. And obviously control of your finances doesn't happen in a vacuum. If you need to use those finances for other goals of the guardianship, how well is it going to fit into kind of that overall approach to what needs to be done on behalf of the person?
And I would caution anyone to think that just because someone has been adjudicated an incapacitated person, that they're not aware of their finances. I've seen countless cases in which, they know their finances more than they know any other aspect of their life. They know how much they should get on a monthly basis. Don't lead with this false notion that these individuals are so unaware. That's further from the truth. They'll tell you more than you can ever imagine.
Great. So I'd like to move on to the next set of questions, looking at conflicts that arise during guardianship. Before doing that, first I want to acknowledge Rachel Gersett has joined us. Rachel, thank you so much for joining us, and excited to hear your input in the next set of questions. Also, if anyone that's watching this has any questions, please, there's a Q&A function. I encourage you to ask those questions in there, and after the moderated portion of this in a half an hour, we'll start answering those. So the next one, my next question is for the whole panel, which is when there's a conflict between what an IP wants and what's in their best interest, how should a guardian decide the course of action? Let's start with Rachel. You just joined us, and then move from there.
I'm going to throw it to John.
I was hoping you would answer this one, because I think the answer is I don't know that there is an answer. I don't know that there's a way that you could create a framework that's going to be applicable in any case. And obviously there are different types of decisions that have different impacts in terms of the likelihood of coming to harm and how you weigh these things. I think you try and err on the side of honoring somebody's wishes. Obviously, there are, we always say this, you know, people have the right to make bad decisions. And at what point does a bad decision become so bad that it is a manifestation of the incapacity and requires a guardian to kind of override those wishes? And it's different for everyone. And I think that's really what's at the heart of it. If you're approaching guardianship in the way that we've been talking about tonight, which is to say, trying to incorporate the wishes and preferences of the person, it's something you're going to struggle with throughout that guardianship, because there is a tension that's built in there. That's why the guardianship ended up in the first place in most circumstances. And, you know, I think you got to just, one, have as much information available to you as possible to know what those wishes and preferences are, to understand what the risk factors are. And, you know, you as a guardian, that's unfortunately the weight that falls on your shoulders to make those decisions that no one else is going to give you any guidance on. There'll be people to second guess you along the way, and there'll be people who will look back and say you should have done this or you could have done that. But it's going to be you as the guardian who's going to have to put those factors into the mix and come up with the best way forward that you can.
Sorry to just throw it to you. Oh, sorry. Sorry to just throw it to you like that, John. The reason I hesitated to answer is because I've never served in the role as guardian. And so I don't want to speak to that experience because I haven't taken it. And I've been asked to be guardian and I've said no, because it's not something that I'm willing to take on. So that's why I was hesitant. But I think, you know, a guardian does have the power to do what's in someone's best interest versus what someone wants, and to take away the right, you know, the dignity of risk, the failure. And that's why I think that the guardianship should be so narrowly tailored as the statute requires, because someone may be able to make decisions in one area of their life, but not another. And I think that's where that narrowly tailoring the guardianship comes in is so important.
You know, what I would also add, you know, Mental Hygiene Law 81.20 speaks to the duties of the guardian, right? So there's not much guesswork where that is concerned. And, you know, we have to, as guardians, you have to exercise utmost, you know, degree of trust, loyalty, and, you know, all of the above. But I think what's key also is to communicate with the IP, you know, explain, you know, I do understand you want X, but if the need arises, like, you know, for example, if you're asking me to choose between purchasing a new television versus paying your rent, you know, explain to them, you have to live somewhere, have to maintain your residency. So in that situation, I am going to pay your rent. But I think the key in everything, and to foster a good relationship going forward, is just to continue to communicate with the IP. You're going to have those awkward and difficult conversations, but, you know, also look to the order and judgment. The order and judgment will spell out specifically what powers you have. So never lose sight of that. You know, it will tell you, okay, because I've seen situations where, you know, the guardian would marshal someone's assets and income and they didn't have the power to do so. So, you know, don't just jump ahead and think like, oh, you know, I'm here to save this person. No, you're there to really show, you know, honor and dignity and respect to that person. And you're there to really abide by the requirements under the statute, and also to follow the order and judgment to the T. And ask for help when there's ambiguity, right? There's so many people out there. There are many participants in the guardianship process. You know, you have, you know, counsel for the AIP is not going to go anywhere. That person, if they, trust me, if they have a conflict with you as guardian, they're going to go back to their original counsel and make their grievances known. They're also going to go back to the court. You know, and that's the beautiful thing about guardianship. It's very, you know, friendly to individuals and family members. Like, okay, we have a conflict here, you know, let's get some resolve. So, you know, to sum it up, I would say communication is the way to go.
I would also like to take it one little step further when it comes to guardians making the decision as to what's in the best interest of the individual. I just want to make sure that, you know, guardians look at it from the IP's point of view too, that when I'm making a decision for what's in the best interest of the individual, I'm not doing it because it's convenient for me versus, you know, because, you know, we have situations where, you know, a lot of my clients are in the community. It's hard to keep them in the community. And a lot of them will bounce in and out of hospitals. And, you know, a lot of these clients are subjects of Article 81s. And, you know, at times we'll come back and the guardian will be like, oh, can't keep them in the community anymore. Got to put them in an adult home. Well, that's not really always the best answer. And it's definitely not the wishes of my clients. But it is convenient for the guardian. So, you know, I think communication is definitely key. And it's also key for the guardians to look is, you know, are we really doing this for because we want to keep the IP safe, and it's for the best for the IP, or is it that we just don't want the headache of trying to keep this person in the community paying their rent, when they're in the hospital, making sure their Social Security is, still in effect, and their bills are being paid, et cetera, when we can just let the adult home take care of it.
It's an interesting question, like how much do you have to try, to do these things? You can try maintain someone in the community or discharging them from a nursing facility multiple times that it may not work, but that doesn't mean that it may not work in the end. I was thinking today about a case I think you and I shared maybe about 8 years ago where we, tried to move someone out of the nursing facility, and the first time we tried, it was a disaster, and she refused to leave. And at that point, maybe some people would have thrown up their hands and said, look, we attempted it. This is just not going to work. And you were an amazing advocate for that person. And we tried it with a different approach. And lo and behold, she got home and she lived out the rest of her life in her community apartment where she wanted to be. And, clearly we can't know exactly what the outcome is going to be in any given case. But a lot of times it's a function of how much effort a guardian is willing to put in to try and enact those wishes of the person.
Absolutely.
And I'd like to look again at lay guardians because it's sort of sometimes a unique case. And how do you help them or identify conflicts that are personal in nature? For example, a guardian who also may stand to inherit property in a will, or disputes among family members that are more interpersonal than they are about the best interests of the ward. I'll start with Olga and move it to the panel.
Yes, that certainly comes up a lot. It comes up a lot. And what we do is, again, we go back to the concepts and their obligations to act on behalf of the client and do whatever is for their interest. It happens a lot when it comes to Medicaid planning, because if there is, for example, a second spouse, or there is a child that's living with the parent that may end up in the house, it happens when they have to deplete the assets if there's no possibility of doing Medicaid planning at that point. So all that creates problems. We just have to sit down, walk through it with them, explain to them everything is the benefit of the person you're a guardian for. Just for their benefit, it's for their benefit. It happens a lot also in marshalling, when marshalling property, that they come to us regarding joint, which we mentioned in the training, how to set up, what to do with a joint account when they're setting up their guardianship account. And sometimes the person that is in that joint account is someone that they dislike, such as a stepsister, which has happened, and they want to instead keep all the money. One main thing we say in these circumstances is, this is what's going to happen. You're subjecting yourself to claims. There may be consequences on that. And that makes people react also, because also it comes up with in trust accounts. If the person that has the guardian left an account for the person who is their least favorite cousin, they moan and groan when I tell them you have to simply leave that account as in trust for, and you should spend it last, because that's what the person that you're a guardian for, your mom, your dad, whoever it is, wished. And if they have any claim that that was done inappropriately, then I tell them you have to follow that up legally. But your obligation is to make sure that that money is treated the way that the person wanted. One extreme situation that I had as an example on this was a son, not a son, the guardian, the person was the guardian for the grandmother. The grandmother had joint accounts with her daughter, who was the guardian's mother. There was an admission, apparently by all parties, and they knew that the money belonged completely to the grandmother. I made him realize it could be to your benefit to leave those funds, half of those funds with your mother, because it's a closer inheritance for him. It's his mother instead of the grandmother. But at the same time, it was the grandmother's money and he knew it. And if he tried to forcibly keep that money for the grandmother, it was going to affect the whole family's relationship. It was going to be an impossible guardianship. He went to counsel and decided to resign. So it comes to that kind of extreme when the conflicts come up.
And then off of that, does a guardian have a responsibility to family members to keep them informed, and what are the nature and limit of that, both lay guardians and institutional guardians? Start with actually John, maybe you want to give the institutional perspective on this.
Well, I mean, there are some duties now that flow from the Peter Falk law and the amendment to the statute, so that there may be some affirmative duties to notify family of certain events like hospitalization or the passing of the incapacitated person, and any of the other statutory notice requirements that are just a function of Article 81. But yeah, it's also, you know, a good question in terms of how do you just keep people informed on the day-to-day of what's going on with their loved one. And you see very different dynamics, of course, where you have people who you know, live with the IP who maybe are not the guardian. You have people who are out of state, out of the country. And I think for us, the biggest challenge is often in a healthcare context where people want to, you know, call the doctor and talk through all of these medical decisions where they don't have a legal role, and trying to kind of carve out like what's the appropriate level of awareness that someone should have as a family member about what's going on with their loved one versus, you know, HIPAA protected medical information that's being disclosed to a guardian because they are the decision maker in that case. So, you know, and also you got to weigh, who is this person in this person's life? Are they a good actor? Are they doing this for nefarious purposes? And then that can be a challenge too, especially as an agency guardian, stepping into a situation that has 60 years of backstory that you know nothing about, and trying to kind of unpack that and understand who the players are in the guardianship.
Jillian, would you like to weigh in on the duty to the family, or to notify or to not notify for the privacy sake of the ward?
You know, I certainly say you do want to keep the family members abreast of, you know, everything, not everything, you know, what's going on, the crucial issues pertaining to the IP. You know, it's certainly attention, as John mentioned, because, you know, Article 81 does give a preference to family members. So whenever there's a non-family member involved, I automatically, you know, wonder, okay, what's going on? Is there some other factors at play? So, you know, I often keep that in the back of my mind when, you know, kind of putting weight to the family member's opinion. But, you know, certainly under the statute, we, you know, as guardians, you are obligated to, you know, keep the family members abreast of certain things, but also look back to the order and judgment, right? The order and judgment sometimes will tell you, you know, to consult or in consultation with, you know, family members, things of that nature. But what I would, you know, really recommend to anyone, if there is that language and you're privy to it at the time of the hearing, you know, ask for there to be some kind of tie-breaking situation, because you don't want to, you know, get into a situation in which you're locking, you know, horns with a family member, because it's just not going to end well. But, you know, as I said, go back to the order and judgment, see what it says. And, you know, just, and also, you know, the overall theme here, just be respectful, right? You know, it might be your ward, but it is, you know, mom, it is dad. So it weighs differently. But, you know, assess as much as possible. Okay, is this a good actor, a bad actor? You know, what are their motives? Because some, you know, when you communicate with people, they'll tell you. You know, I've had a situation in which, you know, someone said, you know, you're spending out dad's and, you know, my inheritance. It's like, you know, people will tell you what their real motives are after a while. So just be attuned to those things.
I'll follow up briefly on that. Well said, what was said until now. One of the things that I tell people is it depends on how close the family member is, which was mentioned already, and what kind of information are we talking about. But one factor that they tell them you need to consider, irrespective of their own relationship with the other family members, is you don't want to keep this person isolated. So to the extent that the information breeds and helps to keep the relationship with other people going, absolutely encourage them to do it. When it's financial, I would generally say no. And if there is any claim or neglect or misuse of money, then it's their burden to prove it, but they shouldn't have to give financial information to a family member in order to show that they're properly doing things. In a nutshell.
So I want to ask a question in the mental health context, which is for IPs that are not compliant with medication. At what point would you say it is acceptable, or is it ever acceptable for a guardian to intervene? And in such cases, what types of interventions are permitted, and what risks need to be weighed when those are sought? I know, John, we've discussed this, and then I'd also like to hear from Georgiana and Rachel on it.
Yeah, I mean, it's starting with, what can you do? Obviously, the Article 81 has limitations on what a guardian can do in terms of consent and consent to psychiatric hospitalization or the administration of psychotropic medication over the person's objection is never permissible. So there's that as a threshold. But there are legal avenues that a guardian or any person could pursue to attempt to get somebody mental health treatment if they are non-compliant under Article 9 of the mental hygiene laws. So, we've had clients that we've had to do mental hygiene warrants for. Some clients just present as an emotionally disturbed person and get taken to a psychiatric hospital and are admitted on a 72-hour hold. So sometimes it happens not because of the guardian's intervention, but because of something that's happening in their life and how they're presenting to third parties. I think where we as an agency often are struggling is sometimes when do you take that action? It's a pretty dramatic thing to have the sheriff come to somebody's house and pick them up and take them to mental hygiene court. And there's long-term goals that you have as a guardian to try and establish a relationship. And there are ways that can be very destabilizing. There's no guarantee it's going to be successful in the sense that the person may not be admitted to the hospital. So, there's a lot of things I think you have to weigh that kind of look at the totality of the circumstances. There are just some situations where somebody is just an immediate danger to themselves or others, and that's what's called for, and you need to do it because that person or another person is at risk. I think it's in some of the more, for us, like kind of self-neglect type behaviors where it's concerning that somebody, because of their mental illness or arguably because of their mental illness, is not able to maintain their diet for their diabetes, and they're putting themselves at risk and are hospitalized every other week because their blood sugar is at 500. Those ones are, I think, a little bit more challenging, and how to kind of connect the immediacy of the harm to the extreme nature of forcibly committing someone to psychiatric institutionalization or medication. Georgiana, I imagine you've dealt with this a lot in your time.
So in regards to mental health treatment, as John did indicate, there is no way to forcibly medicate somebody over their objection in relation to a guardianship. The only time that can be done is when a patient is in the hospital and it is ordered by a court, or if there is, if a patient is out in the community on AOT, they can be mandated to comply with outpatient treatment, but they still cannot be forced to be medicated over their objection. When it comes to people out in the community, at any point in time, if somebody believes that somebody is suffering from a mental illness and an imminent danger to themselves or others, you guys can call, guardian can call 911. It'll be up to EMS at that point and the police to determine whether that person needs to go in and be evaluated at a hospital. Like John said, there's other avenues that you can go around. There's the mobile crisis team. If you have a client that's in the community that you really want to try to get them to utilize services, but they're not really doing it, and you need some assistance and some evaluation, and you don't want to go get a mental hygiene warrant, try to get the mobile crisis team involved. The other avenue is, again, getting the mental hygiene warrant, which is, a little bit taxing. It's, it can, you have to come to court, make your application before the court. You have to send the sheriffs out. They come back. MHLS represents them on the return of a warrant. Either they will go in, either the judge will send them in or they won't send them in. Sometimes if they do send them in, they can get admitted or they can't get admitted. It all depends on the evaluation by the psychiatrist. The risk that you have there is that, like John said, there could be a lot of resentment. If they, get drugged through this whole process and then they're not admitted, then you're going to have one angry ward on your hands, for you dragging them through this whole process. You can, simply talk and try to encourage the individual to try to comply. But, unfortunately, guardians are really, really limited. Not really limited. They're just basically you have the avenue of Article 9 of the mental hygiene law, just like everybody else does. There's no exception because you are a guardian that gives you the power to do to force somebody to comply with mental health treatment. And the reality is, if somebody doesn't want to comply with it, they're not going to comply with it, and you can't force them to do it.
May I add? I'm sorry. I just wanted to. Rachel, go ahead. Go ahead.
Okay, sorry. No, I just think Georgianne and John, spoke really comprehensively about this. I just wanted to add that when you do call 911, there's a likelihood that as of now, the police are going to show up. And so just to be cognizant of that, and that there have been people with mental health concerns who have been killed by the police in situations like this, particularly if your client or your ward is a person of color. So just to consider, if you are going to have to do that, to try to be present when that happens, so that if police do show up, you could potentially diffuse any situation if you can.
I will reemphasize that it's been reported to us quite a bit when our clients are placed in the hospital and brought in by EMS that they have not been treated the nicest. Even when they were using NYPD to pick up individuals on mental hygiene warrants. Unfortunately, they are not really trained in dealing with people with mental illness. So they don't always know how to work with our clients. And so they end up becoming a little bit more aggressive. We have seen that change now that, at least in Kings County, they are forcing the petitioners in warrants to use the sheriff's office. We have less reports of abuse when mental hygiene warrants have been executed because of the sheriffs, and they have more specialized training.
Excellent point. So we have limited time left in the moderated section, so I just want to move on to the termination of guardianships and the termination or modification of a guardianship. So in Article 81, it's reasonably clear when a guardian has to report changes and seek amendments to guardianship if IP regains capacity. My question for the panel is, what triggers the duty, and how does a guardian assess that a less restrictive alternative or a change in functional capacity has occurred?
I'll speak about lay guardians. Oftentimes with lay guardians, they get an order in judgment. I'm not sure why the circumstances are like that. Maybe because it is a lay guardian. The judge sets an expiration date for the order and gives parameters of what is expected to do during that period of time, such as either signing up for a program or making sure they get benefits or find some certain kind of residence. And once they comply with that, they have to move to extend the guardianship or to ask for an extension, or it will expire. So that pretty much defines, and they go on with it. My experience with lay guardians is that they are pleased to end the guardianship. That is basically how they see it. Other than that, it's on a case-by-case basis. Many times when a person has this kind of condition that there is an expectation that at some point there may be a change, there are support groups, support agencies that they're working with, either social work, medical, or educational, and I refer them to those to get whatever information they need. But the desire to terminate the guardianship, in my experience with lay guardians, is that they are fine with doing it and they actually are happy to see it happen.
For us, we see two very different types of scenarios that have two very different thresholds. You have a situation where you're not really seeing a material change in the functional limitations of the person. What you're doing is you found other services to put in place that can replicate what the guardianship is doing, and the guardianship becomes a more restrictive alternative to what's available to the person and should terminate. And I think you reach that threshold, it's fairly clear. The services are in place. You now have someone that's assisting them with their paying their bills, or you have a surrogate healthcare decision maker who's been found, or the person executed a healthcare proxy, whatever it is that can be an alternative. I think the more difficult one is there a change in somebody's functional ability, and how do you measure that, and how temporal is it? I mean, we have some people we've had where it was a very clear progression. The person had a traumatic brain injury, and when we were appointed as the guardian, they were in a vegetative state, and now they've regained a lot of their functionality and they just are completely different in terms of what their abilities are. You know, others are, mental health presents an interesting dynamic. You know, if you have somebody who the reason why they came into the guardianship is because of the way that they were presenting when they were medication non-compliant and not accessing mental health services, and now they are, you know, when is that triggered? On the first, you know, the first month after they've, you know, been taking their shot, on the third month, after 6 months? I don't know if there's an answer to that. And I think you try and maybe give more, more responsibility and more freedom and start to ease off of the guardianship over time rather than just pulling the support out from it. You know, for a lot of our clients who are older adults and you're seeing kind of more kind of long-term age-related decline in cognitive status, it's probably less likely that you're going to find something that's going to be an alternative, unless you find, you know, the person had actually, you went into their apartment and lo and behold, there's a durable power of attorney and a healthcare proxy and all these things that people didn't know about. But yeah, I think it's a real challenge. And then, you know, like I said, the mechanisms for it. Okay, yeah, you're required to report on your annual account. Is that really a good way for us to be, you know, keeping tabs on whether or not the guardianship should continue on its current parameters? No. And the guardian does have a duty to bring that to the attention of the court. But I don't think there's a clear standard for like, when do you reach that threshold? And it's something a guardian has to be thoughtful about it. How do you link your duties and your responsibilities to that extra work? And that's the thing too, I think about for Olga, for lay guardians. Hey, now you're doing all this stuff. Now you got to make a motion and you got to do all these things to like put the court in motion to actually effectuate that change too. It's an added burden to a guardian.
I'll just bring up one case where I was appointed as attorney for the person under guardianship who had started on her own the process of terminating the guardianship, and the guardian had been on board. And then as things kind of progressed, I think the guardian got a little bit nervous. And so what the court did in that case was put in kind of a temporary plan where the powers were modified, and the person under guardianship really had full control of their life, except for their finances, really. Well, I should say their Social Security finances, because at that point they were working, so they were earning money, so they had control over that. And after a period of time, I think it was about a year, we were able to use that as evidence that, you know, the guardianship can be terminated. So I think there's a middle ground where it doesn't have to be, you know, this relationship's over, it's done. You can have a middle ground where you try things out and then see how it works.
And we've actually done that in a couple of cases. We had one specifically where a client had, an IP had gone to the court, filed their own pro se application. The court decided that they needed counsel. They appointed us. It was a community guardian that we were dealing with. And so we all had agreed actually that we would give my client a 6-month period to show that he could essentially take care of all of his, you know, activities of daily living, including his finances. And the judge in that case actually suspended the guardian's powers for 6 months. And then at the end of the 6 months, we came back and he showed that he was able to be responsible for everything. And the guardianship was ended at that point. So I think trials are very good for, you know, showing that because, you know, it's also one of those situations where if you've had if a person has had a guardian for a significant amount of time, you know, and the guardian has changed the way things were done before, you know, to make it more convenient for them. Once everything goes back to that individual, they still need time to figure out, you know, where's my electric bill going? You know, what's the new banking system? Getting, you know, everything transferred over to that individual too. You know, sometimes the institutional guardians have relationships with banks, and so they don't get charged banking fees. But when the IP gets their money back, all of a sudden, you know, they have an account where they're getting fees. So, you know, which they never dealt with before. So they need to be able to monitor that and handle that and, you know, show that they can properly use their bank accounts, including those fees, and learn about those fees and see what they can do to change those fees so that they're not, you know, overspending every month. You know, so it's these little nuances that, you know, that need to be taken into consideration when trying to transition everything back to an individual, and it should be monitored by a guardian.
And Jillian, actually, you know, what off of that, what duty does the guardian owe during the termination process to basically make the IP whole post-guardianship?
You know, just to reiterate a lot that was said previously, you know, if the guardian happened to marshal the, you know, the Social Security income, they became payee, your duty is, you know, once the court signs off on an order terminating the guardianship and telling you to restore this person, you revert it back to them. If you know, rerouted their mail, you know, make sure they're now in possession of their mail. Have those conversations with them to let them know, okay, this is what we've done during the course of the guardianship. And I will say also, you know, the guardian has an obligation to serve the IP with their annual accounting. So, you know, use those as your roadmap to say, okay, this is what was done, you know, these are your disbursement, your, you know, if most likely they already know, but it's a clear way to really spell out, you know, what's been done throughout the course of the guardianship. So use that as a dialogue to say, okay, everything that I've done, I'm going to restore you back, whether I marshaled your income, your assets, we're going to make sure it goes back into your name and you're fully in control of it. You know, whosoever you need to communicate with in this person's life to say, now this person is, you know, responsible for their own personal needs and property management. You have those conversations.
I would actually like to reemphasize that with the annual accounting, because I can tell you, I have probably over the years I've done this, hundreds of clients, and I don't think any of them get their annual accounting. So they're usually not served on the individual, especially our clients. So I would like to reiterate the importance of that. And, you know, I really do believe that the guardian should stay involved until the person is completely whole, because especially now with like the way the banking laws are and the way the banks are, just think about being a guardian and how difficult sometimes it is to get the assets. You know, it's just as difficult, if not harder, to give it back to the individual. And an individual just can't walk into a bank and say, okay, my guardianship is over, give me my money. They won't do that. And so there's a whole long process. Lis pendens, if you have to put a lis pendens on a piece of property, make sure you take it off, because it's hard to get it removed. Still in the process of doing that with one client. So I would just, you know, I would like to reemphasize that the guardian definitely should stay involved as long as they possibly can to make sure that the IP has everything back in their possession. Not only physical property, but like, you know, their mail, some things simply as mail and utility bills and all of that, and make sure everything's in place, even with providers like mental health providers or doctors, you know, just to make sure that the doctors are clear that you are no longer the guardian, because they will definitely look to you to make the decisions rather than the individual themselves.
Right. So I only have time for one more question myself before turning it over to the audience Q&A. So I'd like to end with a question related to, you know, we've all heard of very high profile guardianship where people did not want those guardianships in place. But I'd like to hear from basically everyone, you know, what systems are in place or should be put in place for an IP that wants the guardianship altered or terminated? And does the fact that the IP, you know, pays for everything act as a barrier to this?
I will speak of it from the perspective of a lot of our clients. Unfortunately, I don't think there are any systems in place really to address this specifically for our clients. The way we usually get clients is through our clients will go to the clerk's office and they'll be disgruntled with their guardian, and then the guardian, you know, the clerk's office will refer them to us. Sometimes they'll go back to the court and the court will, you know, appoint us. Sometimes they'll find us directly just because they're like, nobody else can help us. And then we will have to go back we'll have to see if we can, you know, assist the person, and then we have to go get to the court and get appointed. There really needs to be a system set up for this, you know, something as simple as, you know, the individual being given a Bill of Rights, you know, once an order is assigned to let them know, hey, if you regain capacity in the future, this is where you need to go. This is what you need to do, because they're not told. And so they kind of, you know, they're floundering and they get frustrated and they don't know what to do. Some of them are fortunately are savvy enough to go back to the court. Even if the court examiner You know, we have the court examiners that are involved in these cases, but the court examiners don't ever really speak to the IPs. They just are sitting there reviewing a record, that an annual accounting. If they're obligated to maybe have physical contact with a ward, you know, they will at least have somebody on their side. You know, there needs to be somebody on the side of the IP. There needs to be oversight. And it's not just the court examiner. Either, you know, make it another role of the court examiner, or have another, I would hate to say we need another person appointed, but, you know, somebody needs to be there for the individual, like maybe even a guardian ad litem, or something that can just check in, you know, because all the court examiners are really getting is a little blurb about the individual in their annual accounting. You know, so that's never really nothing is really, and if the guardian's not taking the steps to determine whether there's a least restrictive alternative, or paying attention to, hey, this person may have regained capacity, nobody's going to ever know that, because there's no system in place to monitor that.
Couldn't agree more with that. We talked a little bit, someone raised, you know, the issue of guardianships that have a sunset provision where you're kind of forcing yourself back in front of the court, but in the majority of guardianships where the really only oversight mechanism is the filing of accountings, they're just weighted towards the financial aspects of it. And I say usually only half facetiously, if we file something and I don't provide, you know, the receipt for a pack of gum that somebody bought, I'll probably get a question from the examiner. Do you have backup documentation for this? And that's appropriate. If I say the person's in the least restrictive setting, what's the backup for that? There's no mechanism within the review that's going to really look at what the guardian's doing. Yes, there's a medical statement that you should be getting from the person's physician. Does it really address a lot of the things about whether the guardianship should continue and whether the parameters of the powers are appropriate? Absolutely not. You know, I think the statute obviously has a mechanism for termination and reduction of the guardianship that in theory should work. I think in practice, you know, there's real barriers to somebody getting an application before the court. They don't have counsel. They may not have the ability to retain counsel. I'd be interested to hear kind of Rachel's take on this, because I know you've been in this position as counsel to people who want to challenge their guardianships and kind of how you navigate that. But, you know, we'd be fooling ourselves to say people who are in the guardianship system because they have some sort of functional limitation. You know, unless the system has failed so badly that these guardianships have no basis, you know, that there's an issue that is going to make it more difficult for them to navigate this process, especially if they don't have assistance of counsel. And I think that's something we need to kind of grapple with. And there are clearly gaps in the statute in terms of whether or not reappointment of counsel is mandatory, on how people can choose their own counsel. And I know when we file an application, if it's anything other than something very ministerial like permission to pay an accountant for taxes, I'm going to put in my order to show cause to have counsel reappointed, because I think an adversarial hearing where somebody has the assistance of counsel is going to bring these issues to the forefront. And, you know, sometimes it's going to happen as a matter of course if it's selling real property or expanding the powers of the guardian. But we need to give people, you know, a voice in that, and to say, hey, not only do I not want this, but I don't think I need a guardian at all, or my guardian's not doing their job and they should be removed, or whatever it is that they want to bring to the attention of the court.
Even if it's something as simple as what Olga was saying with the lay people, you know, guardian, it's limited. It's, you know, when they appoint a lay person, they will give it a duration. It's, you know, just because somebody is appointed an institutional guardian doesn't mean that it should be automatic and permanent. So they should have to come back to the court yearly, or, you know, to say, hey, listen, yeah, this person is still incapacitated and this is why.
I think having the court examiner physically meet or talk to the person under guardianship is the bare minimum that we could do in order to improve the system. I think we could model off of other states like California and have really an annual review where the person under guardianship is represented by counsel, gets to go back in front of the court and explain what's going on. And really there's an actual judicial review. I think that's hard to envision with our current system because it would involve so many more resources, but I think other states do it. And I think doing that would really meet the ideals of Article 81. Finally, I mean, an ombuds program. I mean, I think if New York started some kind of guardianship ombuds program, it could be a first step in helping people, because they wouldn't necessarily have the power to go into court on behalf of people, but it could actually start gathering data, because I think that's another thing that's lacking is comprehensive data on what's going wrong and what people's complaints are.
Thank you so much, Rachel. And I just want to thank all the panelists. Now I want to hand it over to Sheila for the audience Q&A portion of the event.
Thank you, Stu. I'll start with a question that perhaps is best answered by Jillian. How should an estate attorney deal with an IP who contacts them to revise a will that estate attorney had previously drafted? Does the attorney need the court's intervention?
So my understanding of the question, there's already been an adjudication, correct?
Yes, so we have an IP, there's been a court hearing and an adjudication of incapacity. It's unclear from the question if the incapacity is total or if there's a tailored order.
You know, so certainly my answer would hinge on that particular fact. You know, again, you know, my universal answers really go back to the order and judgment. What does it say? What powers does the guardian have? You know, but I think at the very least, the attorney should, you know, do due diligence and get in contact with perhaps the guardian, really, just to find out what exactly is going on, instead of, you know, going forward and making amendments or changes to, you know, whatever advanced directives were already implemented. So I think you certainly need to figure out what powers were left in the hands of the IP and proceed from there.
A threshold question as to who the power is vested in to retain counsel, right? Like, even if, and clearly there are different standards in terms of somebody's testamentary capacity or the ability to enter into execute advanced directives that are not driven by whether or not they've been adjudicated incapacitated. But even if they do have testamentary capacity, they may not have the legal ability to retain counsel because that power has been vested in the guardian. So couldn't agree more, Jillian, that, I mean, the ONJ is the starting place for all of that. I think if you were counsel, your first step would be to get on the phone to the guardian and see what was going on in terms of kind of working out where those different authorities lie. And we've had a lot of clients who have executed or amended wills while we've been their guardian, and we allow that to be a conversation between them and their attorney, and the attorney to do their job as a trust and estates attorney to determine whether or not the person has the requisite capacity to make those decisions. And we're just there to kind of deal with the contractual and payment pieces of it that require the guardianship court oversight.
The next question relates to whether or not there is a place or a role for mediation in conflict resolution, either pre-order and judgment, for the selection of the guardian in which the family is in conflict, I guess a situation in which more than one family member is seeking to be the guardian, or post-order and judgment on any conflict where mediation is allowed under Article 81. Have any of you seen mediation used in any of these circumstances?
During the guardianship, during the guardianship proceedings, it is by referral by the judge. So it depends on the judge's preferences. For example, if there is an issue about visitation, that they may try to see if guardianship could be averted, and instead have the parties agree. That's how I have seen it. Post-appointment, I consistently refer family members to mediation when there is a conflict between them. And most rejected, many go, and it's fruitful. It's many times fruitful. I really look forward to mediation playing a much more important role in guardianship than it has until now. How that will be structured, I don't know, but I certainly always emphasize it on my end with lay guardians. Crucial.
And I would say in pre-guardianship, I think it would be very beneficial in family conflicts. I can't tell you how many times I've been in guardianships with numerous family members and they've been fighting over who wants mom, who's going to do whatever they can for mom, et cetera, et cetera. And thousands beyond thousands of dollars were just wasted with us just trying to resolve the case, in court. it would have been much better. All parties would have been much better served, including my client, if mediation would have been tried in those matters.
What I see, I don't know, I mean, just, for post adjudication, I see sometimes that the guardianship judge has to sit in that role, and to hear all the grievances. And I think that's truly just a part of guardianship, because you're really serving the entire person, right? It's, their personal needs, their financial needs. So oftentimes, I don't know if that's, the court's preference, but it kind of happens by default, I think.
I was going to say, I think serving as court evaluator, sometimes you're often thrust into that mediation role, for better or worse. I didn't
want to advertise that piece of it, but yes.
Thank you, everyone. Okay, here our next question, and I think most of and potentially all of you will have something to say about this one. If a ward is unhappy with their guardian and wishes to change guardians, change the power granted to the guardian, or terminate the guardianship, what would you advise them to do? Many will not have the access to funds to retain counsel, and even if they do, will have difficulty finding a lawyer to represent them if they've been adjudicated incapacitated.
So our office my office at the Urban Justice Center and Mental Health Project dealt with this often. We got dozens of calls from people, and there really is nowhere to send them. We had a very small practice doing this work, but very small. So the first thing we would sort of figure out, is this the person in a hospital or an institution, in which case we'd send them right back to MHLS, to police. But if not, we would kind of give some general advice, which is, have you asked your guardian yet? Sometimes a guardian is willing to be discharged for a few different reasons. So we advise people to talk to their guardian first. We would advise them, if they can remember who represented them in the original proceeding, to reach out to that person, to that attorney, who may or may not be available or interested, because they're no longer really required to represent the person, but they might be willing to. If they can't remember, can they find the court paperwork? Can they contact the court examiner? Again, in my experience, most court examiners haven't really been interested in interceding in these types of cases, but occasionally they will. And then finally, we've provided clients with, or potential clients with, pro se paperwork that they can submit to the court themselves. The paperwork is confusing even when it's a model, a sample. We do sometimes tell people, you can write a letter to the court asking the court to appoint an attorney for you. So I don't know if the courts would like me saying that out loud, but I think it's something that people can do, and they have no other option. They really don't.
Yeah, I think that probably exhausts all the available avenues to people, and yeah, it's tough, and I think it's so interesting, because that kind of person that you're talking about, it's a very kind of self-selecting group. That's the person who has had the ability to be an advocate for themselves, and to do all these things, and to make these phone calls, and to keep going. And I think we should be very worried about the people who don't have that access. Either you're certainly concerned about people who are being isolated and just cannot physically bring to the attention of people that there is something wrong, but also people who's just, because of their functional limitations, are just not going to be someone who's going to be able to go, I guess in a pre-COVID world, down to the courthouse and fill out a pro se application and file it with a clerk, even with the assistance of a pro se office. So and I've seen people under guardianship who have been our clients who have been amazing advocates for themselves, and filed a 130-page brief in support of their termination motion, which was amazing and actually very well done and successful in the long run. But it really just very different dynamics for different people who are seeking these, and a big difference between removal of the guardian and the termination in terms of some of the burden shifting and who's going to prove and have the burden of proof in the courtroom as well, that may require a differing level of representation.
I think also there's more room for attorneys to reach out to the guardianship judges directly as well. I mean, we had one case where the long-term care ombudsman contacted us from Kohler on Roosevelt Island, and there's a gentleman living there for 2 years, and it turns out he had a personal injury settlement of $5 million, and he was ready for discharge, but he had been living on Kohler, and his guardian really had done no work, a private guardian, to get him off. And we couldn't represent him for a number of reasons, mostly because we represent low-income people and he had $5 million. But we wrote a letter to the court as a friend of the court. And we said, this is what's going on. You should look into this. And they did. And they appointed MHLS. So I think there's room. The guardianship judges tend to be somewhat flexible.
And that's why I just have to go back and reemphasize that there needs to be some type of physical oversight, yearly oversight once a guardian is appointed, whether it's the court examiner that goes out and puts eyes on the ward, or if it's somebody else, another agency, it must be done. It really needs to be, that needs to be incorporated into the system.
I think it's a good point. You know, what you were saying, Rachel, in terms of like just getting the judge's attention. My experience, the judges who are sitting in these parts, they care about what's going on. And if you can get something in front of them, they're not going to ignore it, especially if there's, you know, something substantive about what's being alleged. And there's going to be a process. I've seen court evaluators reappointed. I've seen obviously counsel appointed. If you can get the attention of the judge, I think in almost every circumstance, there's going to be some process. And obviously there's limitations to our system and the resources that can be put to this. And you know, court can't be going out and investigating because somebody sends a letter every week and, you know, relitigating the same, you know, termination motion again and again. But, you know, I think the judges, when it gets before them on their desk, like there's going to be action taken in most cases.
Next question is primarily for our panelists that have served and serve as guardians. There are two parts, and feel free to answer whichever part appeals more, or both. First, how do you deal with an uncooperative IP? And secondly, guardians are people too, and what are the limits of the guardian's duty? And at what point does the breakdown in the relationship impair the ability for a guardian to be effective? And should the guardian at that point seek to be removed?
I mean, the hardest part of this sometimes are those practical abilities to stymie a guardian's power. Like, you can have all the powers in the world to make medical decisions or to do things, and a person can just impede the ability to exercise those powers just by resisting the interaction with the guardian, closing the door, locking it, not talking to you. There's a lot of ways that those kind of practical impediments can prevent a guardian from doing their job. I think there's a lot of ways you try and approach that, and you try over the long term to build a relationship and to show value of what you can do to assist somebody. And I think the things that we've been talking about tonight, by showing somebody, I'm not here just to take away all your rights and make all these decisions for you. I'm here to help you make your decisions and be the tool to implement those decisions where we can. And hopefully you gain some traction. Sometimes you never will. And that's just the reality of it. And you do your best to keep on doing what you can and affect what you can. You know, the limitation for us as agency guardian, you know, I do have some ability to try different staff members and try different approaches. But, you know, we deal with this all the time. You know, what do I do if somebody says something that's inappropriate, sexually inappropriate, racially charged to one of our employees? Like, what's our duty as a guardian to just ignore that? Like I said, we're people. It's hurtful when somebody yells at you and tells you you're incompetent or insults you based off of some immutable characterization of yourself. Like, and I don't know at what point does that relationship break down that somebody can use those as tools or a sword to basically, I don't want you as a guardian, so I'm just going to say nasty stuff until you have to resign. And I've seen people who are clearly doing it as a very intentional thing rather than because it's their belief system. They just think, oh, it's a way to get this person to stop, you know, to leave me alone. But obviously, if a guardian can't be effective because of that relationship breakdown, you know, it's at least worth bringing back to the court. I don't know that another guardian is going to be effective, you know, where you failed there. But I don't know, Jillian, what do you think? Have you had similar experiences in terms of your clients?
No, I would say really the key is just to be persistent, you know, begin with respect and try to approach it as a guardian, try to approach it in a way that you're trying to solve a problem for them, right? And you let them know, like, okay, if an issue ever comes up, you know, you can call me if, you know, you need help with this. And oftentimes, even though they're somewhat resistant in the beginning, if they do have a problem, they will call you. And, you know, let that you know, whosoever they're entangled with, to say, okay, I do have a guardian and they're here to assist and to help me in any way possible. But just lead with respect, be persistent, and, you know, try to be a problem solver in their life where they will let you in. I think that's the key.
One of our audience members recently completed training and earned Article 81 certification, which is fantastic. Are there any organizations looking for volunteer attorneys to serve as guardians? This person would love to volunteer to be a guardian, and how and where should they apply?
Contact the judges. They'll love to have you.
Is the person interested in being a professional guardian altogether? Because they can contact the guardian in fiduciary services, which is part of Rule 36, and be on the roster.
So it looks like they're already on the roster, and I think you've spoken about it. It's basically, how can one get started as a pro bono guardian?
Send a letter to the judges. You know, they'll love to have you explain to them, you know, you've done the article, you're part of the Part 36 list, you know, you want to get involved. There's such a shortage of professional guardians. So any help that you can offer, they'll be all over it, and you'll be a welcome asset to the court.
And if you say you're willing to take those cases where there's no fees, or someone's in a nursing facility, there are plenty of cases that the court's looking for someone who can do a good job and is willing to take those cases on. So if that's what you mean by volunteer, absolutely. I think the court will have no shortage of potential cases for somebody. And they're, you know, great cases to really learn about a lot of the most important aspects of guardianship in terms of care planning and healthcare decision-making and end-of-life decision-making.
Right, and I will add, probably contact not specifically NASA Supreme Court, because they have made an effort under a model program until now to use volunteer guardians. So that may be a place also to specifically start with.
Okay, and I think this next question will be our last question for the evening. What do you do when cultural competency and psychiatric medicine collide? I have had cases where the IP isn't mentally impaired, but just didn't understand why all of a sudden all these people outside of her community, strangers, are asking these questions about her ability to take care of herself and her finances. And that leads to a psychiatric consult. It a bit overlaps with some of the things we've discussed earlier, but I think the general question is, what should a guardian do if they come to realize that potentially the IP isn't incapacitated? Or
yeah, I mean, to me, part of the answer to that question lies in like how much of the guardian kind of the extent to which the guardian is thrusting that person into unfamiliar situations. Like, you know, it may be easier for a guardian to just say, oh, I got this visiting doctor who can come see you, so that's going to be your new doctor, and I'm going to set you up with all these services, and to ignore the way that this person has been accessing these services in their community, and to, you know, just being in the guardianship system alone, of course, is you know, that might be the first contact somebody's ever had with the court and with, you know, these government systems. So, I mean, that alone, I suppose, can just be very disorienting, and people obviously have differing levels of ability to understand the procedure that they've gone through. But I think, yeah, you got to offer people the services that they would have selected for themselves to the extent that you can, and hope that that does a little bit of it. And, you know, like we said before, having that relationship, trying to explain, trying to contextualize, you know, what you're doing. And obviously that approach differs for every person depending on what that cultural background is, but I think the general approach is probably fairly similar.
I think if I understand the question correctly, I think this is where pre-order and judgment, the court evaluator can be super important, is to come in and figure out, you know, what is a cultural difference and what is really a functional limitation. I think some things, as a court evaluator, I've seen some things alleged in petitions, trying to appoint guardians, and when you meet the person, you really learn, and particularly if you have an interpreter, if they speak another language, you really learn that some of the things are just cultural differences, and this really has no impact on their functional ability. It may just be not something that I'm or you or I are used to. So that's one pre-guardianship thing that a court evaluator can help with.
Well, thank you so much to all of you, our panelists, for such an interesting conversation. And thank you as well so much to our audience for sharing your evening with us. And that's all for today, unless anyone has any final thoughts. Have a good evening, everyone.
Thanks, Stu.
Thank you, you too.
Thank you all.
Thank you so much.
Thank you.
Have a good evening.